Breonna Taylor, a 26-year-old black woman, was awakened by the sound of police crashing into her apartment with a battering ram just after midnight earlier this year. Her boyfriend, apparently believing they were being attacked, began shooting his lawful firearm at the plain-clothed intruders. Police returned fire, fatally shooting Breonna several times, even though she was unarmed. Breonna was the victim of a no-knock warrant, which allows law enforcement to forcefully enter a person's home without announcing their presence. Officers claimed they knocked, but it's unknown how much time they waited between announcement and invasion. A no-knock warrant was not necessary in her case, as police were merely searching for evidence of drugs belonging to a suspect they already had in custody. They did not find any. Between 2010 and 2016, at least 94 Americans were killed during the execution of no-knock warrants, and 13 of them were police officers. No-knock warrants are extremely dangerous to both civilians and police, and in the wake of Breonna's death, it's critical that we restrict how and when they're used. Utah has previously passed legislation in the wake of some high-profile, botched forcible entry raids to ensure that force used in a no-knock warrant execution is reasonable and necessary. Officers must identify themselves as police vocally and on their clothing. They have to wear a body camera, and they can't forcibly enter a person's home for a case involving only drug possession. Utah is also the only state to require police disclose information on how forcible entry and SWAT teams are used. These are good steps that most states should follow, but there's more to be done to ensure cases like Breonna's never happen again. Suspicion of drug possession or knowledge of the presence of weapons do not count as inherently violent and harmful acts. Yet, these have been used as excuses to conduct no-knock searches, putting police and everyone in the house at risk. No-knock warrants should be banned, with exceptions only for cases with imminent danger to the occupants of the home, for example, kidnapping or murder. A traditional knock and announce warrant gives individuals the ability to come to the door and comply with police officers. This protects the well-being of those within the household who are presumably innocent and is less risky for police who don't have to fear being mistaken for an intruder. Police should be required to wait at least a minute before barging through a person's door in order to spare harm to property and the people inside, as well as risk to officer safety. Warrants should also be served during daylight hours unless there's a clear threat of immediate danger. Serving a warrant in the middle of the night or early in the morning can startle household occupants awake, leading them to panic and react without thinking clearly. Police should also be required to explain to a judge whether other people might be in the home before they bust down the door, and the judge should not be allowed to issue a warrant for low-level crimes if innocent third parties might be nearby. Officers should also have to explain what investigative activities they conducted to ensure they're actually going into the right home. Precautionary measures such as these can help protect all parties by mitigating the risk of violence. States should adopt these regulations immediately because we can't risk losing another innocent life like Breonna Taylor. For Libertas Institute, I'm Michelle Aiden.